All right, this is our second lecture on M&A and PE. In this lecture, we'll be talking about the types of mergers and acquisitions. Now, from the legal standpoint, there are three different types of mergers or acquisitions. We'll come to that in a bit. But from a business standpoint, and it's important to understand as part of why companies merge or acquire one another, it is important to understand that there are two kinds of mergers or acquisitions. The first is a horizontal merger, where two companies which pretty much produce the same goods or services come together or acquire one another to create a larger customer base, to create better synergies. Now, for example, let's say if Vodafone were to be acquiring Hutchison in India, what it's actually doing is it's acquiring another company that provides similar goods or services that it already does. This is an example of a horizontal merger. Walmart acquiring Flipkart is an example of a horizontal merger. Both Walmart and Flipkart are involved in retail trading. Flipkart, of course, is involved in retail trading on an e-commerce basis, right? So it could be that Walmart and Flipkart are coming together to form a horizontal merger. From the legal standpoint, of course, it's technically an acquisition, but the purposes of that acquisition is to create a larger customer base, which means that it's a horizontal combination or a merger or an acquisition. On the other hand, a vertical acquisition is one company acquiring another or merging with another, and these two companies produce very, very separate or discrete goods or services. For example, let's say you're a mobile phone manufacturer and you source your microprocessors from a particular company. Now that microprocessor company sells, microprocessors. You sell mobile phones. Two separate goods, two separate ingredients, right? And therefore, two separate customer bases. But as a mobile phone manufacturer, why would you want to acquire a microprocessing plant or a microprocessing company? You would do so in order to reduce costs. Now you know for a fact that each microprocessor that you buy has a cost attached to it. That cost is part of the price that you pay for each microprocessor, but the price that you pay for that microprocessor also includes the operating, not just the operating costs of that company, but also its overheads, also the profit margins, right? So if you take over or you acquire that microprocessor company, what you're doing is, with that profit margin, you can either add it to your own revenue or you can pass on that profit margin because you're selling to yourself, right? You don't need a profit. You can pass on that profit margin to your customers, making your phones cheaper and therefore more competitive in the market. The other ramification is that if you have similar teams that support core operating structures such as finance or HR or sales or marketing, what you're doing is you're effectively removing some of those people from their jobs, thus creating more efficiency as part of the larger company. So these are the advantages of having a vertical or a horizontal merger or an acquisition. Now, mind you, these are not legal terms. These are not terms that are of much importance to us as lawyers, but it's helpful to understand why companies merge or acquire with other companies. From the legal standpoint, there are three kinds of merged or acquired structures. The first is a very simple slump sale or business acquisition or asset purchase agreement, right? In this case, the acquirer or the acquiring company does not acquire the target company. Instead, it acquires the assets from the target company. Therefore, as part of a contract, the contract is between not shareholders of the two companies, but between one company and another. Think of this as a transaction between two companies where, simply put, goods and immovable property are being sold. For example, let's say you're a plastic manufacturer and you manufacture plastics for a wide variety of industries. Enter an automobile manufacturer who says that I want to buy your automobile plastics division, right? In which case you would have to carve out or hive out, right, the division of your plant and machinery and inventory that deals only with automobile plastics. What this does is, so effectively, you're trying to identify those parts of your company or those assets of your company which deal with a particular division. Now, when we're talking about assets, we're not just talking about immovable property or movable goods. We could also be talking about the people who work in that division. Now, mind you, let's say in this example of plastics manufacturing is a specialized field, right? And there might be people who work exclusively on automobile part manufacturing, in which case, as part of the asset purchase agreement, not only would you, as an acquiring company, not only would you want to buy out the plant and machinery and immovable property on which that plant and machinery exists, you'd also want to buy out the inventory, the spares, the goods in stock, the goods in transit, the goods in storage, right? All of that. In addition to that, you might also want to consider hiring those employees of the target company that work exclusively for the automobile part division. So the asset transfer agreement or the asset purchase agreement is one of three legal structures or legal processes that we follow when it comes to mergers and acquisitions. The other two are really mergers and acquisitions. So for the purpose of this course, we won't be focusing on asset purchase agreements so much. Now we know for a fact that the difference between a merger and an acquisition is at the end of a merger, the two companies that come together, one of them will cease to exist, at least legally cease to exist. While you might have the names of both the companies in the same name, so for example, Vodafone Idea, one of the two, the merged entity, will cease to exist as far as the roles of the registrar of companies is concerned. In an acquisition, however, both companies retain their distinctive separate legal identities. In an acquisition, one company simply buys the shares of another company under Section 56 of the Companies Act, which we'll deal with substantially later on. But one company buying the shares of another company, whether as part of a minority or as part of a majority, is typically known as an acquisition. In terms of a merger, two companies coming together, having their assets and liabilities merged, their shareholders also merged, and really the identities of the two separate companies having been merged, right? So these are the three different structures, at least legally, that we follow when it comes to M&A. Asset purchase, acquisition of shares, or a merger of two or more companies.